regulations are also the place where the insurance sector for Japan Post or the mutual aid, not-for-profit insurance societies could be attacked. There is also in this agreement an effort by the U.S. pharmaceutical and for-profit health companies to turn Japan's very wealthy society's health services into a new opportunity for profit. In the U.S., many hospitals are for-profit, the insurance companies are for-profit. We have no national health system. And in the agreement, the rules on services in health apply unless a service is exclusively in the public sector and not offered in competition. Except in Japan, hospital insurance is part of liability insurance. So you have some mixed service in insurance for hospitals. This is the kind of trick that is used to then drag the rest of healthcare into having a for-profit fee-for-service system. We also know, because there have been leaked documents, that there's a proposal in a chapter called Transparency, except it was secret until it was leaked, that is providing a new right for the U.S. pharmaceutical companies to have a seat at Japan Insurance Board decisions about the prices of pharmaceuticals, so that they could contest the lower prices that is provided through your government system. We also know there is an attempt to have extensions of patents, which could have a horrible effect in the developing countries, TPP countries, not only for the treatment of AIDS and tuberculosis, but cancer, high blood pressure, in Vietnam, in the other APEC countries that may join who are developing countries. Next slide, please. We also know of very severe problems with food and product safety. The food and product safety rules limit both the safety standards and the inspections. There is a rule that standards must be only those that are internationally approved, which unfortunately food companies have had a very strong role in. And if you want to have a better standard, you must prove it scientifically is necessary. The problem is the strongest standards are generally based on precaution. You want to be safe rather than sorry. So the labeling of GMOs, the U.S. would argue there is no scientific certainty that this is a problem. So you cannot do the labeling of GMOs, not allowed. Or, for instance, in areas such as the beef hormone. Everyone knows this case from the WTO. The international standards said this is safe, but many countries think this is not safe. In our country, the farmers use this and we eat this. We did not have the power as consumers to fight this. But in other countries, if the farmers can't use it, the people don't want to eat it, then as we say, the people who are eating should be the ones deciding. Unfortunately, in the agreement, the rule is not treat foreign and domestic the same. The rule is a ceiling. You cannot go higher than the set standards. There is also the rule of equivalence. This means that you must accept imports of meat that satisfy the food standards of the exporting countries. This is a problem, for instance, for countries that are worried about BSE. So you would be required to accept as equivalent the system of another country that may not be the same as your country. And this has happened to the U.S. We now have declared equivalent in over 30 countries, and we have, through lawsuits, gotten the documents. And it is enough to make a person a vegetarian to see what has been declared equivalent that is not safe. And labeling, we have now just lost a case, even allowing us to have labels on meat on the country from which it comes. So even if you know the other country is not safe, there is no label anymore that is allowing us to decide. So